Can a spouse obtain divorce or support from his or her spouse while that spouse is in bankruptcy? The answer to that question is it depends on exactly what type of relief the spouse is seeking and what type of bankruptcy the spouse is in at the time. The thing that prohibits creditors, including a spouse, from trying to collect debts from the debtor is the automatic stay. The automatic stay is an order that goes into effect as soon as a bankruptcy case is filed, and it prohibits collection efforts against the debtor, the debtor's property, and property of the estate. The automatic stay is contained in Section 362 of Title 11 of the United States Code, the Bankruptcy Code. Now, fortunately for spouses in divorce and separation situations, there are exceptions to the automatic stay. These are set forth primarily in 362b2a, and they include establishing paternity of a child, establishing or modifying a domestic support obligation. A domestic support obligation is a defined term in the Bankruptcy Code. It's in Section 101(14a), and it consists of 4 different elements which are covered in another video that you can find. Child custody or visitation are also allowed to proceed in spite of a bankruptcy being filed. Divorce itself is allowed while the spouse is in bankruptcy, provided the divorce itself does not attempt to divide property that is property of the estate. Property of the estate, again, is a defined technical term in the bankruptcy context, and it's defined in Section 541 of Title 11 of the Bankruptcy Code. And there are significant differences between Chapter 7 and Chapter 13. Chapter 13 is a planned bankruptcy that might last 3 to 5 years. And Chapter 13 provides that the debtor's post-petition earnings are property of the estate. That's not true in Chapter 7. In Chapter 7, the debtor's earnings from their employment after they file Chapter 7 bankruptcy are not part of the bankruptcy estate. And it's those earnings that are frequently the source for enforcement of support orders and perhaps other obligations in bankruptcy. So there's also additional property and debts that may be at issue in a divorce case, claims that the spouses might have against each other, and property in which the estate might have an interest, for instance, real estate. And certainly the safest bet in Chapter 7 is to either wait for the automatic stay to expire or file a motion for relief from stay. And in Chapter 13, it's certainly to file a motion for relief from stay to obtain the permission from the bankruptcy court to take the actions that the spouse wants to take. Now, a spouse is permitted to collect a domestic support obligation from property that's not property of the estate, and money can be withheld from the income of a debtor in bankruptcy, a spouse, that is property of the estate for payment of a domestic support obligation. And you can see here the gap between these, unfortunately. You can establish or modify a domestic support obligation. You can collect a domestic support obligation from property that's not property of the estate, and you can withhold under a withholding order, a wage assignment, or a Division of Child Support Enforcement assignment, money, even though it is property of the estate. The problem is if you have somebody who's self-employed in Chapter 13, that situation for collection purposes doesn't quite fit into any of the exceptions. Also accepting from the automatic stay is the suspension of a professional license, which is allowed in Virginia in the event someone doesn't pay court-ordered spousal or child support. And similarly, if the non-payment of support, the support owed is reported to a credit reporting agency, as that term is defined in the Social Security Act, that's permissible too. That's not a violation of the automatic stay. So I mentioned earlier the safest procedure is a motion for relief from stay. That's a motion that's filed in the bankruptcy case, and you're asking the judge for permission to proceed with the divorce case or the other action that you want to take that might be in violation of the automatic stay, that might not fit clearly within one of these exceptions. And to go even a step further, an even safer course is to get bankruptcy court approval of any separation agreement or property settlement agreement that the parties reach while either one or both are in bankruptcy. The consequences of violating the automatic stay can be severe. A separation agreement or a property settlement agreement reached in violation of the automatic stay may be void or voidable. Actions taken in violation of the automatic stay may be punished in the bankruptcy court through a proceeding, and if it's a willful violation, the other party can recover attorney fees and costs. So there's actually a safer way to go about this, and you should consult with your Virginia family law or bankruptcy law lawyer to discuss how best to get the relief that you're seeking while you or your spouse or both of you are in a bankruptcy case.